my YouTube channel. On today's episode, I'll be discussing about the 2 years rule of marriage dissolution in Nigeria. A marriage is an institution regulated by law. As such, certain requirements must be fulfilled before there could be a valid celebration or dissolution of marriage in Nigeria. However, the principal legislations governing statutory marriage are the Matrimonial Causes Act and the Marriage Act. In life, nothing lasts forever, as we know. So when a man and a woman exchange vows, walks down the aisle, cut the cake, and do all sorts of paparazzi, one would think the union between them will last forever. Well, by default, it was expected to be like that. But however, there are some instances that could give rise to the dissolution of such marriage. It could be either by the death of one of the spouses or divorce. However, in this analysis, our attention will be tilted towards the 2-year rule of marriage divorce. The principle of law by virtue of Section 30, subsection 1 of the Matrimonial Causes Act is that a divorce proceeding cannot be instituted within 2 years after the date of marriage. For instance, if Clinton got married to Cynthia on 1st of August 2021, the law is that either of the parties cannot bring divorce proceedings from then till July 31st, 2023. The rationale behind this rule is hinged on enhancing the longevity of marriage. Also, the rule ensures that divorce should not be made too easy so that people will not rush out of their marriages as soon as they discover that was not what they expected it to be. Do we then have an instance that could make Clinton, in our example, have a legal grant for divorce? Yes. The exception statutorily provided for in Section 30, subsection 3 of the Matrimonial Causes Act is that a divorce proceeding within the 2-year rule is allowed if, number one of the parties is guilty of exceptional hardship, and number 2, if the case involves exceptional depravity on the other party to the marriage. Furthermore, though the terms exceptional depravity and hardship were not defined in the laws, the courts have interpreted these phrases based on the circumstance of each case presented to them. However, in the case of Fletcher vs. Tate, Mr. and Mrs. Tate married in August 1977, and in April 1978, Ms. Tate applied for leave to petition for divorce. She alleged that her husband often beat her up and he had twice tried to strangle her whilst he was drunk. She also alleged that her marital difficulties were affecting her standards at work, since both of them were police officers working in the same police station. It was held that this leave should be granted. Moving on, if the exception doesn't apply and the marriage has lasted beyond 2 years, the petitioner must then prove to the satisfaction of the court that the marriage has broken down irretrievably by virtue of Section 15, subsection 1 of the Matrimonial Causes Act. This is the only sole ground for the dissolution of marriage in Nigeria. To establish irretrievable breakdown, the petitioner must prove the existence of one or more of the facts stated in Section 15, subsection 2, paragraph A to H of the Matrimonial Causes Act, which are: paragraph A, that the respondent has willfully and persistently refused to consummate the marriage, meaning if the respondent has consistently refused to make babies in the marriage. Paragraph B, that since the marriage the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent. Paragraph C, that since the marriage the respondent has behaved in such a way that the petitioner cannot reasonably be expected to live with the respondent. Paragraph D, that the respondent has deserted the petitioner for a continuous period of at least 1 year immediately preceding the presentation of the petition. Paragraph E, that the parties to the marriage have lived apart for a continuous period of at least 2 years immediately preceding the presentation of the petition, and the respondent does not object to a decree being granted. Paragraph F, that the parties to the marriage have lived apart for a continuous period of at least 3 years immediately preceding the presentation of the petition. Paragraph G, that the other party to the marriage has for a period not less than 1 year failed to comply with a decree or restitution of conjugal rights made under the Matrimonial Causes Act, and paragraph H, that the other party to the marriage has been absent from the petitioner for such a time, and in that circumstance has to provide reasonable grounds for presuming that he or she is dead. In Ekerebe versus Ekerebe, Mohammed JCA, as he then was, held that for a divorce petition to succeed, the petitioner must plead one of the facts contained in section 15, subsection 2, paragraph A to H of the Matrimonial Causes Act, and that if the petitioner fails to prove any of those facts stated in the law, that the petition must be dismissed, even if the dissolution is so desired by both parties. In conclusion, a petitioner has to clear 2 hurdles before the court can grant the decree for dissolution of marriage. The first hurdle is that the marriage must be at least 2 years. If not, then the exception will apply. And the second hurdle is that such marriage must have broken down irretrievably. To this end, I believe that now we understand that for a marriage to be dissolved in Nigeria, it must be at least 2 years, or in the case that there is an exception and we understand the proper grounds for a dissolution of marriage or divorce in Nigeria. This is Official Joel TV. I do videos like this. Please subscribe to my YouTube channel and stay tuned for more.